Did you go through our little list? Because yes. Well, go down there and see and send Richard what I think I've told you. Am I on? Good morning. Good morning. What part of that didn't y'all understand? I'll try it again. Good morning. Thank you. Bow with me. Gracious and good Heavenly Father, again we come asking you to forgive us of our sins, to ask you to lead us and guide us in these next few days. Give us wisdom to do things that are right. Forgive us when we do wrong. Let us remember that we're down here representing all the people of the state of Georgia, and that both sides of this House and Senate need to open up their minds a little bit. Lead and guide us. Forgive us. Give us wisdom, character, and compassion. I ask these things in my Savior's name. Amen. To the wall. I can't stand playing games with you people. And sometimes I think that's what y'all think this is. I will not promise you that you will get any bills on the calendar. And if I hear SB1 one more time, you won't get it. Ms. Tankersley.
Good morning, Mr. Chairman and committee members. Today I stand before you to ask for House Resolution 743. It's simply to create a House Study Committee on annexation, de-annexation, and incorporation, city incorporations. There's a clear need to review our current annexation, de-annexation, and incorporation laws and procedures and consider ways of addressing negative impacts and ensuring that the process is clear, open, and equitable, and in the best interest of all the citizens of Georgia.
Any questions of Ms. Tankersley? Thank you.
Thank you.
Mr. Tanner.
Thank you, Mr. Chairman. I've got H.R. 744 under modified open. I believe it's the fourth one down, first page. This will be a study committee dealing with drones. We've had a lot of piecemeal legislation on drones introduced over the last several years. Appreciate the help from the Speaker's office and Chairman Powell in trying to come up with a plan to be able to address this as a global policy moving forward. And that's what this study committee would attempt to do, Mr. Chairman.
Any questions, Mr. Tanner? Thank you.
Thank you.
Mr. Jackson.
Thank you, Mr. Chairman, and ladies and gentlemen of the committee. I appreciate your service and being here today. And I have before you, and I think it's obvious you don't see me here much, and I certainly won't be back again no time soon. I have before you here substitute Senate Bill 76. It's a simple motorcycle and bicycle bill, and I wanted just to, for shortness of time here, I know you're busy, just kind of relate to exactly what it does. If you turn to the first page of this bill, it's LC 410504S. It just simply says to amend the Georgia annotated relating to motor vehicles so as to provide for definition to provide for the safe operation of motorcycles or bicycles through an inoperative control signal, to require drivers of motor vehicles to stop at crosswalks with pedestrians activated rectangular rapid flash beacons, to make it unlawful to activate such devices when there is no intent to cross the roadway, to remove the provisions regarding the height of handlebars, et cetera, et cetera. What this bill simply does is allows a motorcycle or bicyclist to pull up to these four-way traffic control intersections. They are controlled by a mechanism under the drive, and they will not activate because of the lack of weight of the motorcycle, of the iron content, et cetera, et cetera. And it would just simply allow them to, after watching and looking and listening, to activate that as same as they would a regular four-way stop sign that didn't have a traffic light. Look, they've got to see at least 500 foot and be safe and pull out and go on their way. The addition to this, and I thought was such a great amendment, is put on it in your committee of public safety, the lights, the strobe lights on crosswalks. And it added to the bill. I'm very appreciative of that. It makes the walking of crosswalks a lot safer for our pedestrians. And so if this is a vehicle that can do that, it's worth its time. Thank you very much. If there's any questions, I'll try to answer them.
Ms. Jones?
Thank you, Mr. Chairman. Senator, my understanding is this bill has been further refined from a version we've seen in previous years so that it satisfied some of the concerns that there were previously. Is that true?
Yes, ma'am. This has been a thing ongoing, but I think that the sensibilities of everybody has decided that it's good, and I just hope y'all decide it's good. But I appreciate anything you do or say, and thank you very much. Any further questions?
Yes, hold on, Mr. Fleming. He waves. Mr. Roberts.
Thank you, Mr. Chairman. To my good friend, who is an honorary over here, the honorary South Georgia guy.
Yes, sir.
Just one quick question, though. The part that was added in committee, I think that was a bill that we earlier had here in the House. Is that not correct? Are you aware of that?
Do what? I didn't quite.
The part that was added in public safety in the House to that bill, wasn't that a bill we currently had in the House?
Yes.
Okay, I just want to make sure. So that's the same language?
Yes.
Okay.
It was improved over there, by the way. Thank you. Is there anything else? Thank you.
Mr. Powell. Well,
Yes, sir. Just a question. Is it not true that, we've been looking at this bill for motorcyclists, and these are for the motorcycles that pull up on these strips and they don't have the weight to change it. And in a lot of cases, we've looked at over the years about taking a right on red and such as that, but we've found now that there's situations that they come down the interstate ramps with the red lights and they don't have anywhere to go. And the language we put in here basically said that they have to maintain the burden of proof that they're doing all things possible, but still the reliability would be on them if they did pull out in front of someone.
Yes, sir. Absolutely.
Thank you.
No more questions. Thank you.
Thank you, Mr. Chairman.
Mr. Pack.
Thank you, Mr. Chairman and members of the committee. I bring before you H.R. 724, which is the second bill listed under modified open rule. It's a resolution to create a House study committee on cybersecurity and privacy, looking at a couple things. Number one, the threat of cybersecurity and how our government agencies are responding to that. Number two is to look at the consumer protection laws that we have, make sure some of our identity and our private information gets stolen. What are some of the remedies, and are we addressing that from a policy level? And lastly is the infrastructure that we have of a lot of companies who are in this space to see what economic development opportunities that they are to further study that issue. So the resolution is to create a study committee, set for 5 days, and the members are appointed by the Speaker. Be happy to answer any questions.
Mr. Hamilton.
Thank you, Mr. Chairman. Representative Pack, I was under the impression that we either have one of these going on right now or that there's another proposal for this. Is this duplicative of the effort that's already going on?
I believe there's another resolution that was actually introduced, not a study committee that's going on right now, but that resolution has stalled.
Final question. So I was under the impression that there was the governor's office or someone was already working on a task force or a group doing this currently. That's not the case?
Not that I'm aware of.
Okay, thank you.
Thank you.
Thank you.
Mr. Martin.
Thank you, Mr. Chairman. Thank you, committee members. It's an honor to be able to present to you guys for the first time. I come today with SB 108. This is an insurance department bill. This is also an NAIC model bill, which this would require large insurance carriers, and by large we mean an insurance carrier that writes $500 million or more in insurance premium, to dig a little deeper into their balance sheets. This requires them to look deeper at their investments and look deeper into the risks that they insure to make sure they can meet the obligations to their policyholders. It would require them to submit an annual report on these findings. These reports would contain very sensitive information to them, and they would be confidential, and they would be held in confidence with the Insurance Commissioner's Office. As SB 108, I would be thankful for your favorable consideration.
Wait a second. Mr. Weldon.
Thank you, Mr. Chairman. If I could pose a question to the chairman of the committee. I believe the House has a bill that does a lot of the same thing that the senators advised about this bill. I was just wondering if we know the status of this bill in the Senate.
No, I don't.
Thank you, sir. Could the senator address that issue? I think we have a House bill that's
It is not the
similar.
same bill. It is not the same bill. I know there is a self-reporting bill in the Senate at this point. If I'm not mistaken, that might be the one that I'm carrying, and it may have passed out of Insurance Committee. I could be confused though, because I'm not familiar with the exact bill you speak of. Okay. However, it is not the same bill. This is a department bill here that would allow them to fall in good favor with the NAIC.
Okay. Thank you.
No more questions. Thank you.
Thank you.
Mr. Bethel.
Thank you, Mr. Chairman. Members of the committee, on page 2, still in the modified structured section, the third from the top, is Senate Bill 135. This is a bill I'm carrying at the request of the clerks of Superior Court. It deals with records retention, disclosure, and backup. It also now has provisions that are important to members of the House and Senate alike, dealing with the removal of the sunset provision for the certified process servers, and that was a welcome amendment, and I will yield for questions.
No questions.
Thank you, Mr. Chairman.
Y'all have to be nice to Mr. Bethel.
Thank you, Mr. Chairman.
Mr. Wilkinson.
Thank you, Mr. Chairman, members of the committee. I appreciate the opportunity to be with you this morning. I'd like to request Senate Bill 82. It's on the second page, the second bill under structured rule. This bill corrects a flaw in the distribution process for the taxes collected on big trucks. In 2013, we went to an IRP process, and the state previously was collecting approximately $10 million in taxes on these trucks. Now we're collecting approximately $7 million additional dollars, and some of the counties that were collecting the ad valorem taxes where the trucking companies are located were going to be unfairly penalized. So we worked with ACC, GE, GMA, and the Department of Revenue on this bill, which would transition from the ad valorem tax to the performance-based model over a 5-year period. What it would do in this first year is set a benchmark. every county in the state would receive, to begin with, since there's an additional $7 million, every county would receive the money that they received last year. So no one would be penalized, and then the $7 million additional would be taken and it would be distributed according to the performance-based model. And then at the end of 5 years, all the money would be distributed according to the performance-based model.
Any questions of Mr. Wilkinson? Thank you.
Thank you.
Mr. Stone.
Good morning, Mr. Chairman, members of the committee. I have two bills on the calendar today. On page 1, second from the bottom under modified structure, is Senate Bill 111. This simply allows continuing care retirement communities to provide home health care services through existing regulations dealing with licensing and all aspects of regulation. On the second page, second from the top, is SB 134. This is a bill we talked about yesterday, dealing with putting further restrictions on speed traps to close an existing loophole in the law. I'll be happy to answer questions about either bill.
No questions, thank you.
Thank you.
Mr. Kennedy.
Good morning, Mr. Chairman, and good morning to the members of the committee. I bring to you Senate Bill 128, which is on page 1 under the modified open rule, 3 from the bottom of the modified open rule section. This is a bill that I'm carrying for the State Bar. It proposes revisions to the Georgia Business Corporations Code dealing with officers, directors, and certain changes regarding other provisions to make our code more consistent with Chapter 8 of the Model Business Code. The revisions are the product of the Georgia Bar Association corporate sections work. They're annual, although it's been a few years since these revisions have been done, but they're proposed to make sure that our code section, corporate code section, is current and also tracks the Model Act. These are recommended by the State Bar. I'll be happy to answer any questions.
Is this your first time here?
Yes, Mr. Chairman, it is.
I'm not normally as disagreeable as I am this morning. You come back, you hear?
Yes, sir. I'll be glad to.
Mr. Huffstetler.
Thank you.
Thank you, Mr. Chairman. I've got two bills. The very bottom one on page 1 under modified structure 114. Those that were here yesterday, I went over this one where it's a cleanup of nurse protocol for community service boards. I'll be glad to answer your questions on that if I need to. The other bill, the second one under modified structure, Senate Bill 64. This is from the governor's task force on child support, the second bill that we've put out of that committee that I've been on for 2.5 long years now. And I guess you could refer to it as maybe the I am not the father, well, you are now bill. We've had an acknowledgement of paternity that's had a lot of fraud in it and has caused a lot of problems. And this Office of Administrative Courts, the Governor's Task Force, has changed the language, made it a more formalized process, and this is supported by the Council of Juvenile Court Judges, the Family Law Section of the State Bar, and the Georgia Court-appointed Special Advocates. Chairman Weldon did make some changes in his committee on this, and we're fine with the changes. I'll be glad to answer any questions.
Mr. Weldon.
Thank you, Mr. Chairman. Senator Huffstetler, isn't it true that this bill requires DNA testing examination in order to positively identify the father, so that we don't have the that's the one, oh no, not that one, but this one, maybe not that one, but this one? Basically, shopping around for the father.
That might be a good way to put it. It's a much cleaner process.
Thank you. And that's done before we legitimate or require the child support obligation.
That's a good point, Chairman Weldon.
No more questions. Thank you.
Thank you.
Mr. Hill.
Thank you, Mr. Chairman, members of the committee. It's great to be with you today. First bill I wanted to call to your attention was Senate Bill 63. It's on page 2 under the structured rule. It's a beer that's going to help our small businesses in Georgia that are engaged in distilling alcohol and brewing beer. Appreciate Chairman Powell and the other members of the House who helped us get to where we are in this process. Happy to answer any questions on that. And then on the front page, Senate Bill 203, under the modified open rule, is the World War I Centennial Commission. As we come up to our 100th year anniversary of World War I, we're putting together a commission that will work with the federal commission that's already in place to make sure that Georgia's history is included in this great celebration of 100 years since that significant event.
Any questions of Mr. Hill on either one? No questions. Thank you.
Thank you, sir.
Mr. Black. You miss us yet?
Thank you, Mr. Chairman.
Did you hear me?
No, sir, I didn't.
Y'all, that's the way he was in the house. He couldn't.
He said, do you miss us yet?
Well, it comes with time, you know. It has to start wearing these little bugs on the ear, and you don't pick up everything. So
my
apologies to you and the committee. And I
wait
will
a minute.
say this.
Wait a minute.
I will say this. It is a different world over there.
Come over here and do it. You ain't gonna let me say that. My question was, do you miss us yet?
Well, I miss this, yes.
Okay, go ahead. Long as you miss us.
Thank you. Ladies and gentlemen of the committee, I bring to you under modified open House Bill 175, which is a departmental bill. It's a little bit, but it's not simple because it involves animals, and anytime you involve animals, it gets complicated. But this is requires a health certificate, a certificate of veterinary inspection on the major species that are used in economic significance in agriculture, equine, cattle, horses, pigs, sheep and goats, this type of stuff, and also birds. It exempts poultry that's under the National Poultry Health Policy, and this is also provides that the Commission of Agriculture has authority by rule to address other species that pose a significant health hazard to the animals of this state. Thank you, sir. Any questions?
I certainly hope not. Thank you so much. I'm going to put that on and make sure Weldon carries it for you so we won't understand a thing about that bill. Ms. Orrock.
Thank you, Mr. Chairman, and we certainly are enjoying Senator Black in the Senate, let me just say. I'm here on Senate Bill 109, Modified Structured Rule, and this is the bill that clarifies and addresses the legal issues around end-of-life medical treatment in support of honoring patient preferences about medical treatment. And I appreciate the questions of the committee when I was before you yesterday. I would just call to your attention that some 10 groups have worked on this bill very, very carefully. We had 3 full Health Committee meetings in the Senate. It passed unanimously from the Senate. It passed unanimously from your Health and Human Services Committee, and appreciate the Chairman Cooper's leadership on that. But Medical Association of Georgia, the Hospital Association, the Nursing Home Association, the Palliative Care and Hospice Association, the Georgia Trial Lawyers, the Alzheimer's Association. I could keep going. We've worked with the Archdiocese as the bill moved through the process, as well as Georgia Right to Life. And it's been carefully crafted. You know, when you change a bill like this, you've got to run back through about half a dozen of those organizations to see if they're still with you. So would appreciate your favorable consideration, and I will stop and see if I can entertain any questions for the committee or the chair.
No questions, thank you.
Thank you so much. Thank you. And that amendment that the chair lady and I have discussed is one that we think is very workable to having this go forward. Thank you.
Mr. Dugan.
Thank you, Mr. Chair, members of the committee. This is on modified structure, page 2, top of the page, Senate Bill 131. We talked at some length yesterday. It's a bill I'm carrying for DBHDD, just a cleanup bill. Subject to your questions, if there are no questions, I respectfully ask that you select this bill.
No questions, thank you.
Thank you.
Mr. Williams, and y'all, he has put another one in the pot. He's working hard.
Yes, sir. Thank you, Mr. Chairman, members of the committee. I present to you SB 95. It's on modified open rule, halfway down. This bill allows real estate brokers to place money they have in a trust or escrow account into an account at a financial institution, as long as that account is federally insured.
You mentioned the magic word there at the end on all these new accounts that you want to put the money in. Are all of those federally insured?
Yes, sir.
Okay. Go back over here to we recommitted one of your bills yesterday, 160.
Yes, sir, that's correct.
Tell us what happened.
We went back to committee yesterday. We met. We made an amendment, kind of just a technical amendment to make sure that it was accomplishing what we wanted to accomplish, and that is that law enforcement officers, whenever they come upon underage drinkers, that their first line of defense is to issue a citation first, then to assess the situation, and if need be, to then arrest. Right now there's a lot of arresting going on, and police officers feel like they have to for various reasons, and this is something that is being supported by the prosecuting attorney as well as several police chiefs.
And Mr. Weldon.
To the Senator, your Senate Bill 95,
yes,
this doesn't give any new powers to realtors. This just says they have to keep the money in a financially insured institution that's insured by the federal government, right?
Correct, yes, sir. Right now the rule is they have to put it in a checking account at a bank. Mm-hmm. So we're just opening it up to any account as long as it's federally insured at a financial institution.
Good bill, thank you.
Thank you.
When you put it in another account, you put it in a checking account, does the checking account earn interest?
That would be up to the bank, but yes, it could possibly earn interest.
And these other accounts, are they interest accounts?
They could be, yes, sir.
Who gets the interest?
That's agreed to upon the parties that the money is held in trust for. It could either go to the party who gave the money for trust, or it could go to the broker. It's based upon the contract that they signed.
Okay, thank you. No more questions.
All right, thank you.
Mr. Hill.
Thank you, Mr. Chairman of committees. First off, I would like to report that yesterday the Senate Finance Committee took up about 10 of your bills out of 25, and we've got the remainder on our agenda today. In the Finance Committee, moving right along, Chairman Powell and Majority Leader and I have spoken in the last 24 hours extensively on some of those bills. I'd like to bring to you Senate Bill 69. It's on the front page. It's the modified open rule. It's fairly straightforward. It's related to the Georgia Defense Force. The Defense Force reports directly to our governor. They're called up, these individuals are volunteers, they're called up for usually 2 to 3 days in the state of Georgia. They're not deployed overseas, while the governor is in the process of calling up the National Guard. And right now their employment rights are not protected, so some of them risk their employment by being called up for a couple of days at a time. And this bill simply protects them from being fired while they're doing the service on behalf of the people of the state. And with that, I'd be obviously willing to take any questions, and Chairman Yates will be carrying the legislation.
No questions, thank you.
Thank you, sir.
Mr. Gooch.
Good morning. I'm not here to give a committee update, but I'm here to ask for Senate Bill number 4. Senate Bill number 4 deals with the Atlanta Beltline. It's a good economic development bill. We passed this bill out of the House and the Senate last year. It got hooked up in a conference committee, and the last hours of the night we failed to get it back over in time to get it printed on your desk. There's been a lot of work done on this in the House Transportation Committee. There was an amendment made dealing with one of your representatives asking for an MPO to be created in his district, and I ask for your consideration to put it on the House floor today, please, sir.
Mr. Willard.
Thank you, Mr. Chairman. Senator, I had conversations, but there's been a change that limits this to what they call the martyr counties, which is Fulton and DeKalb only. Is that correct?
Yes, sir.
And the question, I guess, concern being raised was, is this putting a greater burden on the local municipalities in these areas as to the cost of relocation of utilities on road projects?
Yes, sir. It won't deal with any of the roads in state or county or city roads, but there was a lot of discussion, and Chairman Hamilton actually got an amendment passed in Transportation Committee that some private utility companies favored, but some of the local governments did not favor. So that's an issue.
What has it changed then in that area?
Let me see if I can find that in the bill. I don't see Chairman Hamilton in the room, but
I'd like to include Forsyth County in there if we could.
This bill was, as you know from last year, was written strictly for the project of the Beltline, and it specifies in there the size of the acreage and the number of miles of trails. So there's not another project like it in the state today, which obviously could change. And then the amendment for the dealing with the MARTA counties was either more assurances that that wouldn't happen.
Project, okay, it describes a project, I believe, as being, what, 10,000 acres?
Yes, sir. Shoot, let me see if I can find that too. It's 22 miles of trails and 10,000 acres or greater in impacted area, dealing with the Redevelopment Act. So what we did is we basically changed the definition of transportation projects to include surface transportation. So that was the underlying meaning of the bill. 10,000 or more acres and at least 10 transit miles within the area of operation of the sponsoring local government.
All right, so the concern that I'm raising regarding other municipalities that do not have a project as described would not be concerned about, or should not be concerned about, relocation of utility costs being borne by them?
Yes, sir. The bottom line was the utility company was trying to recoup its costs from the city of Atlanta of about $6 million, and they failed to do so at this time. The city has not paid them for the streetcar project. Has nothing to do with the Atlanta Beltline project, but there's some issues there trying to get a debt paid, and so.
Are we legislating then to go back and have something done that's already occurred?
No, sir, I'm not. That was not my change. That was your change in your House committee.
Okay.
Hopefully we'll get that taken care of and worked out. Hopefully the parties are continuing to work. That's what we've requested, that they continue to work on that through the conference committee.
Thank you for that explanation.
Yes, sir.
Ms. Jones.
Thank you, Mr. Chairman. I did have a question. On line 51, where you define it narrowly so that it won't affect other areas, and it looks like it's defined very narrowly. Why is it also necessary then on line 73 to restrict it to MARTA counties? Couldn't you remove lines 73 through 76 because you so narrowly defined it on lines 51 through that section?
73 through 76?
Yes.
I believe that was existing law. That was already in, I don't see that we had changed that.
No, lines 73 through 76 is new language. It's underlined.
Which version are you looking at, ma'am?
The one in my book.
What?
LC 391047S.
Okay.
It's the section where it restricts it to a MARTA.
Yes, ma'am, and that change was also made in your committee, in your House committee.
It was added?
Yes.
Okay.
That's one of the requests, I think, of Representative Setzler.
So you didn't have it in yours?
No, ma'am.
Okay, thank you.
Mr. Setzler.
His question and to Chairman Willard's question. Two things. First of all, on the issue of paying for utility relocation, under the MARTA Act, it's only the MARTA counties that on projects that involve MARTA transit, they bear the cost of utility relocation as a MARTA cost. So if you're doing a rail transit project in MARTA counties today, unlike other road projects, MARTA bears the cost of utility relocation in those counties. So the Beltline, in this case, would bear utility relocation costs at the project level, just like MARTA would bear it at the project level. So that's yet another reason to limit the application of the broad powers provided under SB 4 just to MARTA counties. The second issue is SB 4 does provide very, very broad powers where one or a series of governments can delegate powers to one local government as the managing entity, as it were. And there are some strong concerns in the committee that because this is for the Beltline, let's make sure it applies to counties, Fulton County where the Beltline currently exists. It could expand to DeKalb or in this case Clayton if necessary. So there's no impediments to the Beltline doing what it needs to do. But the broad powers that SB 4 gives for one government to delegate powers to another government would not extend statewide. I had grave concerns about that. There's some other people from other MPOs that had concerns. And this ensures that the Beltline has the powers they need to execute the Beltline without this being a statewide bill that has implications that weren't really contemplated.
Mr. Chairman, if you lived in Fulton County, would you have those grave concerns as well?
I'm glad to address your questions offline. Again, what this does is ensures the powers that are sought to be given to the Beltline can be given to the Beltline without any impediment.
Beltline is not a MARTA.
I understand that, but the point being, this does not change provisions in those counties dealing with existing transit delivery and how those costs are borne. This candidly keeps there for me an unintended consequence statewide in impacting how utility relocation costs are borne. It does tie into Chairman Hamilton's amendment, and I'd be glad to address it with you offline. I think as you delve down into the details, you realize this doesn't put any burden on Fulton, DeKalb, or Clayton that otherwise wouldn't be borne.
Mr. Willard.
Thank you, Chairman. With all due respect to my good friend, Representative Setzler, it does change what is long-standing policy in this state dealing with transportation policy as to the cost relocation of utilities, because it doesn't just affect roads, it doesn't just affect sidewalks. The fact is that transportation needs as defined in the Georgia Code addresses such things maybe that do involve what is addressed as this Beltline system around the city of Atlanta. And I'm afraid we're going down a slippery slope here when we start changing what's been long-standing policy of the state addressing the cost of relocation of utilities in an existing public right-of-way. And right-of-way is defined very broadly and include what is this beltway. Now, you do have a right of, who is there, the priority, who came first. Before it was a right-of-way, was it a location for the utilities as to the question of who has the relocation of those costs? But I have some grave concern of where we're going with this bill.
Mr. Gooch, you can jump in anytime you want to.
Could I just simply ask respectfully if the revisions that were made in your transportation committee is causing the heartburn, that we strike that amendment from Representative Hamilton and move the bill? The rest of the bill seems to be clean, and it's important to the city of Atlanta for the economic development project that's brought thousands of jobs for this area. I would ask you to consider that.
Last question, Mr. Setzler.
Thank you, Mr. Chairman. I'm going to let Representative Hamilton speak to his utility relocation costs. That was not the purpose of my amendment. So I'm not hostile to that. My concern is the broad powers of SB4, where one government delegates powers to another. If it's intended for the Beltline, needs to be limited to the Beltline. I would have grave concerns if that could be applied statewide. So the utility issue is not mine. I want to make that clear for the lady.
Thank y'all.
Thank
you, Mr. Gooch. It will be I think the bill is important enough that we continue working on it. I don't think that an amendment needs to come from the rules. I think that should be worked out in conference committee when we, if it passes the floor, to work that out. Okay. That's all right. All right, Mr. Miller.
Thank you, Mr. Chairman, members of the committee. I'm here today to speak with you and request Senate Bill 190, which is on page 2, the last bill under the modified structure rule. And this is a cleanup from a couple years ago. We had House Bill 457. I'm disappointed that Representative Ramsey's not here. He worked with us on this bill a couple years ago, but this closes a couple of loopholes that were unintended consequences were left open. It prevents casino-like situations or proposals that have been, you've probably read about in the media, that were proposed in DeKalb County a few months ago. And then it cleans up some additional legislation from a couple of years ago. And it also ensures the integrity of the lottery's terminals and their contributions to the Hope Scholarships.
Any questions? Thank you.
Thank you, Mr. Chairman, members of the committee.
Mr. Golick.
Thank you, Mr. Chairman. I'd like to respectfully request for Senator Hunter Hill, Senate Bill 63. This is a bill that's gone through a strenuous process. It is the bill is not all that proponents want, but also it is also a bill that can pass. And with politics being the art of the possible, I think it's positioned to pass and to move the ball forward on that issue and to create jobs. Ask for consideration on Senate Bill 63.
Okay, let's just start. Mr. Benton.
Thank you, Mr. Chairman. I'd like to put my name aside, Senate Bill 109.
Mr. Stevens.
Mr. Chairman, just to follow up on Representative Golick, this bill totally keeps intact the three-tier system in the state, and that's important. So I put my name beside, of course, Senate Bill 63.
Mr. Weldon.
Thank you, Mr. Chairman. I would like to ask for Senate Bill 64 And on Senate Bill 76, I would ask that that be held at least one day so that we can review the provisions of that bill. I've got some trouble with the prima facie evidence that's on lines 45 through 50.
Mr. Willard.
Thank you, Mr. Chairman. I have two bills I'd like to put my name by and hopefully get through. That would be Senate Bill 135. This was one that Senator Bethel spoke to, and you were so kind to him in your remarks regarding Senator Bethel. And also the one that was the corporation bill that was Senator Kennedy's with Senate Bill 128. You know, it's his first time here. He made a good presentation.
Ms. Cooper.
Thank you, Mr. Chairman. When the time is right for you to consider House resolutions, I would like to ask for 612, which is the fibroid education and awareness one. And I would like to put my name by Senate Bill 109. That's a very much needed bill. And also I'd like to put my name by Senate Bill 114, which would help our community health centers. Thank you.
While you've got the microphone, Ms. Cooper, you've got one amendment to a bill that's on the floor today.
I do, sir. Some people felt like maybe that a comma was in the wrong place, and that could have opened up and said that this company could ship all drugs when really it's only shipping home dialysis fluids to people who have end-stage renal disease, and so they just removed the comma.
Since it's built on, let's go ahead and do that. We've got, I assume you move on that.
I move.
Is there any opposition to the amendment? Okay, it's on. I bypassed you, Mr. Setzler. You're the first name on 109 as an amendment.
Thank you, Mr. Chairman. Would like to offer SB 109 appropriate time. What it simply does is to Senator Orrock's bill, any changes to this physician's order form that's promulgated by the department would simply require the approval of the Health Committee of both the House and the Senate. They could do this in session or out of session. It just makes sure that there's openness in a modest level of public and legislative oversight to this all-important form that deals with life-sustaining treatments. Again, this process mirrors what we've done in the last 5 years in other areas of law, and feel like it's appropriate. I'd be glad to answer some questions too.
If there's questions of Mr. Setzler, I want a hand raise. Mr. Willard.
Thank you. I'm concerned where he says this is an ongoing process. I don't know where we've ever had forms coming back to be reviewed by both bodies and have to be approved as a general bill. What we do have, Mr. Chairman, is rules and regulations which are promulgated by a department, and they come usually to the chair of certain committees for review, and if not objected to, become applicable. We're going to take on having all forms coming up to the General Assembly for review. That's what we'll spend most of our time doing, and I question the veracity of what we're trying to accomplish here as being necessary.
I'd like to speak to that if I could. To Chairman Willard, I appreciate the question. If you recall back in 2009, 2010, when we acted on SB 200, there were concerns in giving the executive branch the sole authority to appoint a planning director. There were concerns in creating the process of a 5-year strategic transportation plan for the state. This legislature acted and required that those plans and the approval of the director came before the joint House and Senate Transportation Committee for approval. The purpose being was it's an intermediate step between hard coding something into statute and completely delegating it to the department to do it at their sole discretion. All this requires is there be a level of legislative oversight to make sure a form that affects people's life-ending decisions is done in an appropriate and open way. That's what this does.
Well, thank you, Mr. Sessions, but that's the question was, what forms have we had coming up to this level for consideration through both houses as we do a bill? And I go back to what I was saying. We recognize rules and regulations on that basis as to the chair of certain committees to review, and that's where I think the appropriate level should be, not to have come through us as a bill.
Ms. Abrams.
Thank you, Mr. Chairman. To follow up on Representative Willard's point, Mr. Setzler, can you give an example? Because the way this is written, if there is a change made that's required by federal law, for example, there's a Supreme Court decision that has to be implemented, under the terms of the legislation, the amendment you're proposing, these physician orders would basically be held in stasis for up to 9 months until we reconvene, because the way I read this...
It's not true. And I can tell you how, I appreciate the way this question. I'll let you finish the question.
Wait a second.
If I could be allowed to finish
Ms.
my
Abrams,
question.
not through.
Thank you. The way I read this, and certainly not having a comprehensive understanding of the operations of this body, I too am unaware of any form that we have ever required come back before this body in order to make any modification, which could include scrivener's errors that had to be corrected simply because of a misprint. I think this is I'm very concerned about this and would like to understand from the chairman, from Mr. Setzler, if he can give other examples of forms that have this level of requirement.
I'll speak to your first question. This does not require an active statute. This does not require the General Assembly to be in session. All this requires is a simple vote of the House and the Senate Health Committees to approve the form before it's promulgated. There's no issue. The issue is not, and again, if I could, Mr. Chairman, I know there's some mumbling. I'd like to speak to the issue directly. All this requires is the committees in session or out of session to review and by simple vote approve this form. This is what this form does, and I want to make sure members understand this. This is the form where individuals, pursuant to a durable power, previously pursuant to a durable power of attorney, in this case having that same power, someone signs and says, I don't want to receive any nutrients intravenously, I don't want to have any hydration. This is a form where someone signs without their ability to consent, because if they're incapacitated, what's going to happen to their life. This is the most significant form perhaps we've ever put in law, and all it requires in session or out of session is a simple vote of the House and Senate Health Committees, so that we've not completely abdicated this life-altering decision to the department itself. That's all this does. It can't be mischaracterized.
Ms. Cooper.
Mr. Chairman, Representative Setzler and I had a discussion about this. My name is on this, but to Senator Abrams, Chairman Abrams, Representative Abrams, if it's going to cause a problem, then
Minority Leader.
Minority Leader, thank you, sir. I'm against the amendment. I explained to Representative Setzler that we had that process where I get the changes, and so does Senator Unterman, and we have a chance to look over them, and we can object. I also explained to him that if we were out of session, I would have to call my committee back in. I would have to pay them a day per diem to get them to be able to vote, and that would be a very expensive proposition. What he informed me, when you do this form, if the person is still, before this form goes into where it is a order, the doctor discusses it with the person, and they have to be able to discuss it with the doctor, or it has to be discussed with the person that individual trusted enough to make them their designated person to make this kind of decision. So, but what Representative Setzler told me, his problem was that he thinks in the future we might have a department that might somehow put the questions on this form, this is how I understand what he said to me, that somehow or other would lead people maybe to do things they otherwise would not do, and maybe perhaps in their life, or not want their life sustained. I really don't think it's necessary, and if it's going to cause any problem with this law that we need so badly, I would withdraw my name from the amendment.
Well, we're not going to have any more discussion about it. How's that?
Thank you.
What we're going to do is I'm going to let you vote on it. You have an amendment. Mr. Setzler, I assume that you move on your amendment. All those in favor of the amendment, raise your hand. All those opposed to the amendment, the amendment is defeated. Okay. Mr. Powell.
I'd like to ask for SB 82 under structured rule. This will correct a distribution problem that's penalizing some of our communities that were relying on this revenue.
Mr. Rice.
Same.
Same. Mr. Green.
Thank you, Mr. Chairman. I want to put my name by House Resolution 743 and Senate Bill 63.
What was the last one, Gerald?
63.
Okay. Mr. Dixon.
Thank you, Mr. Chairman. I want to put my name by Senate Bill 95 and Senate Bill 135.
Mr. Allen Powell. I can't hear him. You have absolutely the worst microphone in this building, apparently. Mr. Peake, see if yours works.
1, 2.
Hey, yours works.
Thank you.
There you go.
I'd like to ask that Senate Bill 141 be sent back to the Public Safety Committee, and also at the proper time, if Mr. Weldon's questions get answered, I'd like to ask for Senator Jackson's Senate Bill 76.
All right, the first thing is he's asking that we send 141 back to committee. Any opposition? It's back. And it's on the yellow sheet. And the second part was?
At the proper time, I'd like to ask for Senate Bill 76. I think that Mr. Weldon had a question, but whenever his questions get cleared, which I'm sure they will.
Okay. Anybody else? Mr. Rogers?
Thank you, Mr. Chairman, or excuse me. Put my name next to House Bill 76, please.
House Bill?
Senate Bill 76.
Okay. Just to let y'all know that we've had a request that be held for a day. This is, I'm not holding anything after today. They're either on their merits or they're dead. So we're getting to the short time. And if I hold something, it might, I'm going to allow that hold. Anybody else? Mr. Knight.
Yes, Mr. Chairman, I'd like to put my name next to Senate Bill 63 and Senate Bill 82.
All right. And I think he put 10 bills on today for us. We got lots more bills than they got, and he put 10. I'm going to show a sign of good faith here. We'll start counting after the first three under modified open. HR 612. This is the calendar for Friday. We have a move. Any opposition? It's on. Under modified open, HR 743. Any opposition? Under modified open, House Resolution 744. Any opposition? All right, let's count them. 1, 2, 3, 4, 5. Modified open SB 69. Any opposition? It's on. Modified open SB 175. It's on. Any opposition, excuse me. It's on. Modified structure SB 4. Any opposition? Got an opposition? All those in favor signify by raising your hand. Opposed, same sign. It's on. Under modified structure SB 64. Any opposition? Under modified structure SB 79. Any opposition? It's on. Modified structure SB 131. Any opposition? So, modified structure SB 134. Any opposition? Modified structure SB 135. Any opposition? Modified structure SB 139. Any opposition? All those in favor, raise your hand. Keep them up a second, hold on. All those opposed, raise your hand. 1, 2, 3, 4. 1, 2, 3, 4, 5, 6, 7, 8. It's on. Which one was that? Okay. Modified structure SB 148. Any opposition? It's on. Modified structure SB 190. Any opposed? It's on. Structured SB 63. Any opposition? It's on. 1, 2, 3, 4, 6, 7. That's it.